what are the qualities you look for? And experience and education are important. I heard somebody say one time that of all the things you can think about, one of the most important to think about is the mindset that a person brings to their job as a Superior Court judge. I'd like each of the candidates up here to tell us a little bit about the mindset that they would bring to this job and how it would affect their decisions.
I'm going to define mindset in my viewpoint, in that the truth of the matter is that most people read and understand on a 5th grade level or less. From my experience, many people who go before the Superior Court have no idea what's going on.
Let me stop. Can anybody tell me, of the people that are on Superior Court, how many judges are on Superior Court now? 20. Okay. So how many of them are former prosecutors?
About 7 or 8, 9.
Okay. So almost half of them are former prosecutors. How many of these candidates are former prosecutors? Or current or former prosecutors? Let me just ask this question. So how would the hat that you have worn for whatever number of years as a prosecutor affect your ability to be fair to a defendant who comes before you when you sit on the bench? You just ask the people who've been prosecutors or representing the government.
I'll start. I've been a prosecutor for 20 years, but I've been a black male in Fulton County for 44 years. I've been a black male in Fulton County longer than I've been a prosecutor. I grew up in South Fulton County. I've been on the Old National Highway. I've been on Rugby Road. I came through Welcome All Park in Red Oak. So I understand what goes on in our communities. I understand the challenges that we face coming up as youth in our community. I was in Shannon Mall being followed when I went to go get my mother a Mother's Day gift from my first little job at Wendy's. I was in there being followed by security every place I went. So I know how this happens. So how can I still be fair and be a prosecutor? Because I've been that. I haven't represented the person. I've been the person that has been followed, that has been profiled. So that's how I can be fair, my own personal, real life experience.
Well, I would just say this. Pastor, we got to do something. I'm going to pray for you, Pastor. I'm going to pray for you.
But you need to leave an offering if you're going to pray.
Well, I don't come to the Lord's house without an offering. I think that one of the things that you should know about prosecutors is that when we prosecute, even though we are representing the state of Georgia as well as all of the victims who have either been hurt or harmed in some way, we as prosecutors have an obligation to ensure that the entire process is fair, to ensure that a criminal defendant is also receiving a fair trial. And so when you have that responsibility as a prosecutor, you have a responsibility to ensure that the entire proceeding is fair, one. But I too have had personal experiences. When I went to law school at Vanderbilt University and was trying to finish a term paper, I was held at gunpoint by a law enforcement officer. All over an alarm unbeknownst to me that was tripped, that I walked by, and the officer just literally pulled up and asked me where I was going. Of course, I knew I didn't have to tell him, but before I knew it, I was looking down the barrel of a gun. I have also, in traveling back and forth between Nashville and Atlanta, been profiled. Every time I get stopped, if I have more than one cell phone, even though one is personal, one is business, the reality is that I get questioned about why do I have 2 cell phones or where am I going? And so I too have personal experience as a young black male growing up in a community where there have been tensions between law enforcement officials. But if you ask every one of the defense lawyers that has dealt with me, they want to deal with me because I have been a fair prosecutor. Not one will tell you that Banks is unfair. And so that's where it starts.
Mr. Cox, you have been a prosecutor, but you represented the government.
Absolutely.
So how can you be fair to somebody who
Can I answer the same
against
question?
the government?
Yeah, I can. It's all about perspective. The United States of America has been my client. The state of Georgia has been my client. Fulton County has been my client. On the other end of the spectrum, A little boy who was hurt at a local store was my client. A local elected official, an African-American female in South Georgia was my client. So what I'm suggesting to you is having the government as a client does sort of color your view. I think that the best perspective comes from the well-rounded perspective, and that's what we need on the court.
So to say, but you represented the city of Atlanta, the Atlanta Public Schools. How can you be fair to somebody who is the little person who is in court against, you know, a government agency?
I can be fair because it was ingrained in me as a child of the civil rights movement, personally discriminated against, integrated Southwest High School before black people were allowed to live in Southwest Atlanta, that you treat people fairly even if they don't treat you that way. Now, I will say to you, I look at everyone objectively, and you want someone on the bench who is committed to fairness, justice, and accountability. I will say to you, when you are on the bench, you have to make crucial decisions. And I'm a baseball fan. And so the standard in a criminal matter is beyond a reasonable doubt. People say, well, we just call balls and strikes. I said, no, we don't. You have to know the rules. And the best rule is the base runner's rule. If the ball and the base runner get there at the same time, the base runner is safe. So if it's a close call, the defendant is not guilty. So you want someone on the bench who has a mindset of being objective, of fair, who knows the law, knows how it should be applied, and who has the courage to stand up when the community is standing there before you saying, I want this child's head, I want this person's head, but the state has not made their case. You want someone who can stand up and say, I'm not accepting this plea bargain because you have not given me facts to support all of the elements that have to be proven in a burglary on this particular case. They may be guilty of criminal trespass and trespass, but not burglary. So you want someone who has the courage, someone who believes in fairness, justice, and accountability.
So before I turn the mic back over to the moderator, I want to ask one more question that goes to this whole question of mindset again. But this is a hypothetical question. Imagine that you've been elected, you are serving on the bench, okay, and you have a case in front of you today in which there are two witnesses and only two witnesses. There is a police officer and there is the defendant. And each of them testifies, and their testimony, one's testimony is the exact opposite of the other. There's no consistency at all. How do you go about the process of deciding who to believe? Start with you.
Well, let me tell you something. That's what I do every single day on a regular basis, is trying to determine the credibility of witnesses in all of the trials that I have actually had, after interviewing them, after speaking with them, and ultimately after they have to testify. The reality is that one of the first things that you want to hear is whether or not there is any corroborating evidence that supports their testimony. You're not going to go into court as a superior court judge and simply believe an officer's testimony over a lay witness simply because they're a law enforcement official. Vice versa, you're not going to believe the layperson's testimony over a law enforcement official just because there is tension between law enforcement and the community. The reality is that you just have to sit and listen to every single thing that is said and try to determine whether or not there is anything that corroborates any of the testimony that you have listened to. And if there is some corroboration, I believe that you will be able to make a ruling. Generally, jurors are the ones making those decisions on a regular basis. However, superior court judges do have motions hearings where law enforcement officials are involved, where lay witnesses are involved, and sometimes have to be the finder of fact in those cases. But listening to all the evidence is the first start.
I think that the answer to that question is ultimately it's an issue of fact. Jurors make those determinations. To the extent
When there is a jury, and sometimes there isn't.
when there is a jury, and in this case you gave a criminal case example, the more likely scenario is that there would be a civil case. Even more likely, to the extent that there are disputes regarding facts, jury decisions. But to the extent that you have to evaluate the quantum of the evidence, preponderance of the evidence is the civil standard, and you evaluate the evidence from that perspective. You use the appropriate legal standard, and you make the call.
Thank you. The question was about criminal cases. And in criminal cases, the state's burden of proof is beyond a reasonable doubt, which is the highest standard that we have. When there's a tie in the evidence, Ms. Edwards is right. The tie goes to the defendant. So if a judge is listening to evidence and doesn't know who to believe, and all things are being equal, there's no other corroborating evidence, the tie is supposed to go to the defendant. Having said that, every case is different. It is up to the judge to determine the credibility. In your scenario, it's up to the judge to determine who's credible and who's not. And based on the facts and circumstances of the case, sometimes it's going to be the defendant that's more credible, and sometimes it's going to be the officer. But what we have to do is leave aside, we have to separate our raw feelings from what it takes to be a good judge, and decide our cases based on the evidence in your scenario.
We're talking about two issues here. We're talking about a jury trial where a jury makes the determination as to whether or not whose testimony is correct, and then we're also talking about a judge sitting over a criminal matter, listening to motions that have been filed that require the prosecutor or the defendant to call lay witnesses and or law enforcement officials. That is when the judge is actually the finder of fact. So there are two sets of issues. When you asked the question, I was of the mindset that you were speaking of the judge actually being the finder of fact in a criminal hearing where there is a motions filed and a law enforcement official testifies and a layperson testifies. If that is your question, I stand by my answer. On the other hand, if it's a jury trial, I don't have to make that call. I just have to preside over the proceeding, and the jury makes that call.
And I also wanted to get in that we're talking about two separate standards. That fact scenario was based on criminal law, which, as Mr. Margolis said, is a higher standard. But again, there's a different standard in civil law. And again, the majority of the cases that come before that court are not criminal.
We're going to have a debate between the two of y'all.
All right, what has been said is that the tie goes to the runner. I agree with that, but I don't think it stops there. 51%, the scales of justice tipped a little bit in the state's favor. They're still not guilty. Beyond a reasonable doubt is the standard the state is held to. So it's not just that the tie goes to the runner. The ball can get there first, and then the runner get there a little bit afterwards. And in the criminal justice system, the runner's still not guilty. And so what I've been doing for the last 20 years is making those determinations before we even go to court. Before I take any case to court, my evidence is not 51% or 52%. There's corroboration, there's witness testimony, there's documented evidence and physical evidence. And so in that situation where you got two witnesses and they're testifying to the same thing, the state hasn't proven its case. And as a judge, even on a criminal case, I'm sitting there now, I have to make a determination, do I grant a motion for directed verdict? And in some cases, I would have the courage to say, hey, state, you haven't proven your case. We're going to end it right here and not let it go to the jury.
I would just simply add this. The prosecutor is the person that makes the decision to bring the case to court. And most of the cases in Fulton County and throughout this country, criminal matters are resolved through plea deals. A lot of people accept a plea deal because they say, you're looking at 5, but if we go to trial, you're looking at 30. So a lot of times you don't even get to the point of having trials. Most of the cases are resolved prior to a trial through plea deals. A lot of people feel like prosecutors overcharge, so people are more or less coerced into accepting a plea deal because they don't want to roll the dice, go to trial. That's the way the system works. There's discretion at every level. The first level of discretion is the police officer. He decides whether or not to charge you, to send you home to your parents, or to take you. The prosecutor decides after that whether to charge you, and if so, what. Then there's some things the judge has discretion over, but for the most part, all of the discretion lies with the prosecutor.
So the question, as I recall, was, how do you go about deciding who to believe? This is the work that I've done for 12 years in this county in bench trials nearly daily. And what happens is you have to learn to trust yourself and what you're hearing. But you also have to apply standards. And the standards are the state has the burden to prove that somebody violated the law. And as a result, if somebody else is saying, like this officer in your example, is saying, he went through the stop sign, and Mr. Johnson's saying, no, I did not, if there's no other evidence, he cannot be convicted. Because in this state, somebody's testimony that you did something wrong is not enough. So, back to the question, the defendant would get off, because the defendant should be off. They should have never been charged to begin with. And it is your turn.
I'm going to see if I can speak up the music. I agree with Sterling Eves. One of the most crucial things that a judge can have is the ability to listen. And the question was, you've got a police officer and an accused. Who should you believe? Well, there are contradictory stories. How do you decide who should you believe? We do have standards and rules that we have to follow, as Ms. Eve said. But one thing that we also want is wisdom. You want to be able to trust your gut feeling after you listen to the facts. Now, the truth of the matter is, in Georgia, in Fulton County, even in the United States, you don't have indictments against police officers for doing wrong. Truth of the matter is, police officers are usually believed over individuals. So I commend the candidates that they would at least listen and weigh the facts, which should be done.
Okay, as I hand the mic over, I'm going to ask everybody to take 10 words or less to talk about an issue that usually you can't pass off to a jury in that sense. Give us 10 words or less that summarize your philosophy of sentencing. Sentencing.
Again, there are rules of procedure, rules of law that a judicial judge must follow. When there is an opportunity for discretion, then again,
10 words now. 10 words.
in 3 words,
No, that's 30 words.
in 10 words, I'm not counting the and a, but there are rules of law, and a judge has a discretion, and to apply it based on wisdom. Is that it?
Sometimes judges are judges or attorneys are attorneys because we don't like math. So anyway, I'm just saying, that's when we get into court, we get into trouble. Yes, you do. Yes, you do. Okay, 10 words. 4 that I wrote down. Here's what I would take into account and have during sentencing. Compassion, the biggest part of all of it. The integrity of the person making the decision, also known as judicial integrity. And lastly, fairness. Big part of it.
I believe I'm the only person here who's had to make that decision about sentencing someone, but in juvenile court, it's considered sanctioned. The main thing you consider is the effect on the community. Is the community going to be more at risk with this person remaining on the streets? Look at the family. Is there support there in the family for that person in that community? And then you look at your victim. what is fair to the victim. We cannot forget about victims. So if there's an opportunity for alternative sentencing that provides for effective rehabilitation, I am all for it if it keeps the community safe.
In words.
Can you count?
You listen to the facts, you get the person's record, you get the mitigation, and you make a determination. Each case is different.
Each case is different, but as a judge, you need to look at more than just the severity of the offense and a person's criminal history. At the end of the day, and I make these decisions all the time as a magistrate judge who's responsible for sentencing people in magistrate and state court. At the end of the day, I've got to decide, is the community, is the judge and the community just mad at this person, or are we afraid of this person? If you have a good person that's made a bad choice, I'm going to try to do everything that I can to help and support that person and encourage them not to come back in a positive way. If the defendant is somebody who has a history of terrorizing the community and we're afraid of that person, then that person's going to have a tougher time with me as a judge.
How do you determine if somebody's a good person and certainly deserves that chance?
You have to look at all the facts and circumstances of the case. You have to look at all the factors in that person's life. You have to hope that person has an effective advocate that can speak to those issues. Because on the other side, you've got a prosecutor that's asking you to lock this person up for 10 or 20 years or however long. And as a judge, you have experience with those things as well. When you've heard a large number of cases, you know what you expect to see in those cases as far as what you want to hear in order to be able to give somebody a second chance. I believe in second chances. I believe in alternative sentencing. But we have to make a determination. It's our job to make a determination as to when that's appropriate.
Okay, thank you. Mr. Cox?
Fairness, discernment, risk of recidivism, safety, or community.
Mr. Banks?
Think about fairness, think about compassion, think about facts and circumstances, but I also think about it's probably one of the worst parts of the job.